Justin, this is the Global Digest think tank group. You are our guest today. And I don't know, how can you consider yourself?
Well, now I feel a little bit intimidated, but from all your lofty guests. But I'm a paralegal in Ontario. Ontario is a very rare gem in that paralegals are actually licensed to practice, or I should say, provide legal services to the public without the supervision of a lawyer. And so we are essentially taking care of access to justice and ensuring those who would usually meet financial barriers, getting into legal representation no longer see those barriers. We have, we can represent people in criminal courts on what we call summary convictions. We can represent people in most tribunals, things like landlord and tenant board or labor issues, as well as civil court where up to $50,000 worth of damages can be represented by a paralegal. So again, the main idea here is to create access to justice for those individuals who, again, would be facing financial barriers that usually come with expensive lawyers. Not all lawyers, but for the most part, and the best lawyers you're going to get are quite expensive.
Right.
Second to that, I am a college instructor for the paralegal program across three colleges in my province of Ontario and in Canada. They designate us as professors. I'm not suggesting that I myself am a university level professor, but I am a college level instructor with the title of professor as designated by my institutions.
I mean, it's great.
We have a Ontario paralegal license, which again, Ontario is the province that I reside in the country of Canada. And again, our province is quite different in the sense that they've licensed paralegals to provide legal services to the public without the supervision of a lawyer. And so I have a P1 paralegal license to do just that. So traditionally, paralegals were and continue to be for the most part of the world, and certainly in America, more in a support capacity to lawyers. Essentially a law clerk, but with a little bit more legal training to assist lawyers and their firms with filings, with certain low-level tasks that would require some level of expertise, but not exactly that of a lawyer. Whereas in Ontario, we are licensed to provide those services to the public without that supervision of a lawyer, of course, within reason. And of course, that representation reflects our level of education, which is 1 to 2 year programs, depending on the college you go to or the program you take. And so we are different in the sense that lawyers don't have much barrier to who and what they can represent, whereas paralegals, to go back to my original statement, have limitations. For instance, in the criminal courts, in Canada, we have what's called summary or indictable offenses. Indictable offenses, of course, are the more serious offenses, things like murder, rape, assault bodily harm, assault, aggravated assault, and where summary convictions are more things like theft, under $5,000, assaults, which can be what we say elected to be summarily. And so I wouldn't say the lower end of the criminal enterprise, but I would say that the more serious affair, the more public-facing interactions with individuals, such as landlord, tenant boards, and things of that nature, paralegals have no real restrictions there, and so we can represent people in those private interactions. And so it's actually worked out quite well. I feel like the people of Ontario have been very well served in this arrangement, and I think it's something that should be modeled throughout the world. I think the more individuals that we let into the legal system provide a ladder or a bridge to legal services that were not once possible for those who couldn't necessarily afford a lawyer or I should say a traditional lawyer.
I see.
It's a paralegal diploma is a great bridge towards becoming a lawyer. There's not right now a direct one-to-one comparative where if I take paralegal program, for instance, that allows me to get into law school, but it certainly helps when it comes to your law school application. We do have, for instance, at Centennial, we currently do have a essentially a partnership with Leicester University in the United Kingdom. That allows for paralegal students to be accepted into law school in the UK, where they would take a large portion of their legal studies and then return to Canada with that degree, both of us being in the British common law system, they would be transferable as far as knowledge that was learned in those courses. So it's not a direct linkage to becoming a lawyer. It is essentially its own thing, its own licensing, but it certainly helps individuals who are trying to get their feet wet, decide whether or not they want to get into law, as well as provide legal training so that when you do get into law school, you are far and above most who have no or zero law interaction whatsoever.
This is
I teach summary offenses, provincial offenses. So summary offenses, again, are the lower level offenses in the criminal code, as we call it in Canada, which is the statute that outlines criminal activity and what is designated as criminal activity. Provincial offenses is a province by province act that essentially governs the regulatory offenses of each province. Um, and so I teach that as well as practice management. So I teach students how to prepare for their sole practitioner businesses, or which are essentially small businesses in a lot of ways. Um, and I also teach. What else do I teach? I've taught ADR, which is alternative dispute resolution. So things like mediation, arbitration, things of that nature. And so again, the paralegal diploma here program is not necessarily a law degree, but it certainly is a pathway to getting licensed in the province of Ontario to provide legal services without the supervision of a lawyer.
I see.
We wouldn't be considered law school in any sense of the word, but we are a career-focused diploma program that readies paralegals to provide services to individuals. Again, and it needs to be stated quite clearly without the supervision of a lawyer. Something that I must reiterate is not done anywhere else. This is the testing ground for it. And in my opinion, since its inception in 2007, it has worked quite well. We are now coming up to our 20th year anniversary as a licensed profession. The paralegals of today that are graduating from college are a lot of the times undergraduates from university who've decided to become paralegals to see if they enjoy the law before they take that next step into law school, as well as many people see this as the be all and end all of their educational journey, that becoming a paralegal is their aspiration. It is a noble cause, as I said, as we are providing access to justice, which is the literal reason why we were licensed, to the public, because in my mind, everybody deserves representation before the courts or the tribunals or whatever it
Sure.
may be. It's absolutely essential that individuals have that voice. One of the first things to go in a society that's about to fall is the judicial system. When there's no longer
Right.
trust or reliance in the judicial system, it's not too far after that a society tends to follow suit.
Definitely. I mean, no doubt, paralegal work is very important and a lot of things to prepare and to do legal related. I mean, for the court or for any legal issue. I mean, even sometimes I guess paralegal work is more than lawyer or judges, because lawyer and judges, I mean, judges mainly they just make decision. They don't prepare anything. It seems it's not much, but for legal is really you are the main working detail. Everything. I guess compared to lawyer and judge, paralegal has more work and they are more, in my opinion, they are more important because if paralegal are not good preparation, the case will be the case will be very bad. If paralegal doing well, I think the case will be very good because lawyer and judges may not willing to do preparation or they don't want to go detail something like that. Maybe you don't know about that.
Well, look, again, in most traditional senses of paralegals, or the term or word paralegal to describe somebody's designation in a legal office, you're absolutely correct that they do a lot of the was as we say groundwork or grunt work. That they do a lot of the filings and the legal writings and research to provide to the lawyer. I do believe lawyers and judges work immensely hard, especially in my country. I've had the honor of knowing many criminal defense lawyers, and a lot of them don't have support staff. So it is just them doing the from zero to, from A to B, everything that's required. And judges, although they do have a lot of assistance from their judges, secretaries, and things of that nature, until the higher court levels, it's not like they have junior lawyers or people doing their articling with them. They are tasked with creating their decision, making sure it's well founded, making sure that it relies properly within the case law that's been presented. And so, although I do appreciate the praise, I do want to make quite clear that, at least here in Canada, I believe everybody's workload is quite equalized, and I think now that paralegals have this role in Ontario, that we provide the preparation and then also the execution on our own files, and I think again that makes us so much different than the rest of the world, and I really do wish people who view this discussion consider it in their home countries or in their home provinces or territories or states or whatever it may be, because it is changing, right? We have another province, British Columbia. There are some American states who are trying to figure out a way to either license junior lawyers, for lack of a better phrase, or paralegals that can handle more administrative tasks and appearances and files in a fulsome manner, as opposed to being supervised by a lawyer. If only to unclog the justice system, if only to grant access to justice to those who need it the most.
I see.
We are officers of the court. We are
I see.
not counsel. It's important to make that differentiation. But we are respected in the court. Our role has developed. A lot of judges, newer judges who have essentially become judges in the era of the paralegals licensing, have been greatly welcoming. There's a lot of great Justice Brock Jones, for instance, and here in Ontario, he's a provincial court judge, absolutely a champion of the paralegal role in the court. There are many civil court judges who feel the same way, and many administrative tribunal adjudicators who have expressed similar thoughts. It's, again, to me, the judicial system is one of the strongest pillars of any society. The ability for individuals to understand, to interpret, and be able to anticipate their punishment for perceived slights against society is absolutely imperative for a functioning society. Otherwise, we have dictatorships or kings and queens, off with their head, as Alice in Wonderland says, right? And without that protection from the courts, and also we have the Canadian Charter of Rights and Freedoms here in Canada that protects us from the state. Without these documents or these procedures or observations, we would not be, in my mind, the shining the shining beacon of justice that I truly see us as we are.
Right.
I'm a paralegal who represents private clients outside of
I see.
any government body or courts. And just like lawyers, some lawyers will become crown attorneys or prosecutors, some will become defense attorneys. We have the exact same situation with paralegals. And paralegals can become prosecutors on a provincial or city level to enforce provincial or municipal bylaws or laws. And so they usually are prosecutors in the provincial offenses courts. A lot of paralegals act as support capacity in the Ministry of the Attorney General, which is our governmental department that oversees the prosecutions of individuals. And so it's kind of a hybrid, right? We are just like lawyers within the government, outside the government, and more we are enmeshing ourselves within the legal system, which again, in my opinion, is to the great benefit of people. For the most part, at the prosecution office, which a lot of people don't realize, and I'm sure you're aware that people see the prosecutor and the court as one entity, but actually the court is a third party, unbiased mitigator of both sides, submissions. And so paralegals may work in the court in support capacities, whether it's court clerks or in the Crown office working as support staff for the Crown, as well as I said before, being prosecutors themselves in the provincial level courts, provincial offenses courts, I should say, sorry, and private practice. So the same way you see lawyers as far as where they can operate what side of the coin they are on, whether it's prosecution or defense. Um, Paralegals are actually well represented as well in that same regard.
I see. So, as you said, most paralegal may work in prosecution office, right? Also,
Yeah.
it may be work at the court.
The police are a separate entity. They are the enforcement agency for the government's or the state's laws, right? And then, of course, the court is a third party arbitrator of both sides' submissions as far as if a law's been broken or not. And then we have the prosecution's office and the defense's office, right? And this plays out in different forums, whether it's the adjudicator and the prosecution for the statute that's essentially being adjudicated or presided upon by a justice of the peace, which is a lay bench here in Ontario. We have provincial court judges, which are classically trained lawyers who become judges after about 10 years of experience. And we have justices of the peace, which is a lower level of, I would say, trier of fact. They preside over the provincial offenses courts that I've described earlier, as well as some of the more administrative tasks in the criminal court division, such as set day courts and bail hearings, things of that nature. And so paralegals don't necessarily have a presence in police offices unless they're maybe perhaps part of their legal team where they're
I
deciding
see.
whether or not. Obviously, they're unionized and they're probably more likely going to have a lawyer who represents their interest in many different forms, but that doesn't mean the lawyer doesn't rely upon paralegals to
I see.
execute those tasks.
I see. Groundwork, a lot of groundwork in prosecution office, isn't it?
Yes. I would say, though, that a lot of the paralegals who practice or provide legal services do so in a private sense. A lot of us work in defense. In the landlord tenant board, for instance, which is a board that deals with disputes between landlords and tenants. Surprise, exactly in the name. Paralegals work on both sides, right? They work for the landlords and the corporations that have holdings as far as buildings and rentals, and they also represent those who are facing eviction or some sort of landlord tenant issue. And so, it's the I would say the number of paralegals who work in some sort of support capacity for defense and or our defense themselves is a lot higher than those who are working directly for the courts as municipal or provincial prosecutors in the provincial offenses courts or in a support capacity for the Ministry of the Attorney General Prosecution Division.
You see.
So so I do criminal law. And so there are, like, for instance, again, indictable and summary offenses. Paralegals are designated to summary offenses. This is for people facing up to 2 years in jail. As we say, 2 years less a day. Anybody facing 2 years less a day in jail, for the most part, can be represented by a paralegal, as long as the Crown or the prosecution has elected, as we say, summarily or to proceed summarily and not indictably. Once it is indictable or is elected to be indictable, we are no longer able to represent, and a person would need a lawyer in that sense. But for a large portion of today's crime or criminality, a lot of it is summary offenses. A lot of it's simple thefts, simple assaults, domestics, and things of that nature. Domestic, of course, would be intimate partner violence, and where paralegals have definitely gotten a stronghold. I will say, though, there's not a lot of individuals like myself, and this isn't to self-congratulate or to be conceited, but in reality, a lot of paralegals are still intimidated by the idea of going to court, representing a client on their own. The prosecution is a lawyer, the judge is a lawyer, and you're a paralegal, and it can be quite intimidating. A lot of what we say imposter syndrome can kick in. But I feel like when people, and this is why I do so many extracurricular educational advocacy for the profession. I want to provide knowledge to paralegals so they can find strength in knowledge and then move forward and perfect what is the true intention of our licensing, which is access to justice. It's imperative and it's so vital to me that the public has a voice in this forum. It's so unfortunate to see individuals be railroaded by a very complex and bloated legal system that is very complicated in many ways, right? We have, so much so that now we have what's called the plain language movement, where we're trying to move away from legal jargon because much like an individual facing a very precarious medical issue, nobody wants to hear all the medical jargon. They want to know what exactly is wrong with them, right? And that's where the old saying, "Give it to me straight, doc," comes from. And a lot of the times in the legal world, clients just want to know, their options, what's happening, what dangers do they face as far as prosecution or jail time or criminal records that could affect their life for several years. And so paralegals are vital to this. And if I could leave one thing behind in this world, it would be knowledge for the next generation of paralegals so that they could take up where we have taken up from the ones before us and continue to break down the barriers of financial access to justice. I just feel like it's so important. If the common man or the lowest rung of our society, and I don't mean lowest rung to be rude, I just mean it as far as descriptive, can't access justice, then it says something very, very sad about our own society, that individuals who need it the most are usually those who are barred from it. And I would fight that with everything I have in me to make sure individuals have that access.
I see. You said a paralegal officer can directly file in case of 2 year, below 2 years.
Yes, anybody
Any
facing,
criminal case, right? Below 2 years.
yes. Yeah, so there's very little difference as far as how we operate in our permissible area of practice. We show up to court for the client. We engage in negotiations with the prosecution. We seek to see if there's any charter issues. Charter issues, I'm sure they play out differently in different countries, but here in Canada, we have the Canadian Charter of Rights and Freedoms. They protect us from the state. Section 8, for instance, is protection against unreasonable search and seizure from the government or the government agencies, such as police officers or jail guards. Section 9 protects us from arbitrary detention, which means that the grounds for our detention have to be expressed to us in a reasonable time frame. And these charter rights are not subject to much change. That these are charter rights that supersede the statutory laws that are created in the legislature. So paralegals assert those rights. 11D of our charter, for instance, enshrines the presumption of innocence. And so any law that, for instance, puts the onus on the individual without reasonable or articulable grounds to do so would be considered an affront to 11D, the presumption of innocence. And so much like a lawyer, we go in there and we represent our clients to our fullest abilities. If we cannot come up with a good negotiated resolution pathway or there's no charter issues, the next step would be trial. We go to trial just the same as any lawyer. We do examination in chief. There's very little difference as far as how we represent our clients in the criminal courts. Once we are permitted to do so, as long as it's a summary offense that's been elected summarily by the prosecution. In Canada, our system is one that the prosecution puts forward the charges and the defense defends them, and the court hears both sides and decides whether or not somebody is guilty or should be acquitted. So we never directly engage the prosecution in advocacy, except for the fact of negotiations to see if we can come up with a joint resolution position that would see a more favorable outcome for our clients. If that can't be established, then we go straight to trial, and we observe in Canada an adversarial system, and therefore all information and evidence against our client must be disclosed as per a case law that we call Stinchcombe, which outline the exact parameters that a crown attorney has to operate within when it comes to disclosure requirements. And so we do all of that. There's another great case called Boucher, which essentially solidifies the Crown's role in the process. And in saying that, the Crown is not to get what's called tunnel vision, which is to only see the client is guilty and to ignore any counter evidence, that they must take the evidence at face value and base their prosecution on the merits of that evidence, whether it goes for or against your client. And so all that comes together, and we go to court and we argue. And when I say argue, I mean it's argue in the most respectful sense, and we negotiate, and we do what we can to ensure that the wheels of justice keep turning. I mean, there are some offenses that you could do at court, like contempt of court, for instance, or things of that nature, where there's a direct charge laid from activity in the court. But for the most part, what brings you to court would be an officer laying charges, a police officer. Then the prosecution is then in charge of proceeding upon those charges. So unlike America, for instance, where the prosecution has a large decision on whether or not to lay charges, right? The district attorney, for instance, Canada has a system where the officer decides, whether or not charges should be laid. And then the prosecution decides the merits of those charges and will either go along with and proceed with the prosecution or withdraw the charges based on, as we call it, reasonable prospect of conviction, meaning that there's a lack of evidence or a prima facie case, as well as, and of course, prima facie means that it's obvious on its face that it's not a convoluted, crazy wall of connections, that it's pretty clear that there's a crime made out here. And also, or whether or not it's in the public interest to proceed, meaning if a 75-year-old lady down on her luck steals a stick of gum, is it really in the public interest to try to convict her? Is that a real reasonable usage of public resources? And for the most part, the answer, thankfully, is no. And therefore, so the prosecution has that obligation, again, as per
I
Boucher,
see.
to determine the level of validity of the charges laid by officers.
I see.
So part of the negotiations is providing counter evidence to the prosecution to consider. If our client has, for instance, an alibi, meaning that they weren't there, that there's verifiable proof that they were somewhere else and could not physically be at the point of the crime. If the client is facing some hardships that need to be in consideration of their sentencing or their position on, or the Crown's position on sentencing. If there is things that we could do as far as upfront work, like anger management or counseling, or alcohol counseling, or more specified areas of rehabilitative work, then we provide all of that work to the prosecution and then commence our negotiations through what's called a Crown pretrial, which is a discussion pre-trial where we try to determine the merits of a resolution. And so, again, much like a lawyer in the adversarial system, the paralegal takes up all the same advocacy-based roles for their client.
See, so between paralegal can submit the case to the prosecution without any lawyer hiring directly.
That's
You
right.
can do.
We would, of course, submit documentations. We would point to areas of the charter where the police have infringed upon our clients' rights, and that would all help the prosecution determine the validity or the reliability or the viability of the charges as laid by the police officers. Police officers are human beings. There's many great officers, and I teach this to my students all the time to try to brush our paint a broad stroke approach to policing is not fair. Many police officers, women and men, put their life on the line. They're great contributors to our society, but there are some that are subject to human nature. And sometimes you get a little bit overzealous, or sometimes you get too involved or emotionally involved, or you become angry or frustrated. And that can play out in the arrest and or detention and or way in which you proceed with an individual. And that's where we step in as paralegals to ensure, and lawyers as well. I just want to make sure, but I'm speaking from the point of view of my own role. And we step in and make sure that our clients' rights are protected, that they have been protected. And if the Crown has presented evidence that suggests otherwise, then they have a real duty to determine the validity of the charges. And if they don't agree, then we go to a motion hearing in the Ontario Court of Justice, and a judge will determine the validity of our arguments and whether or not there is truly a charter breach. There are many considerations that go into this. A case that we rely on is called RV Grant. It's a grant. We call it the Grant test, which speaks to the admissibility of evidence that was obtained with a charter breach, right? So if I arbitrarily detained you or searched you illegally, the evidence that I obtained as an officer in doing so could be inadmissible in the trial, because it would essentially bring the administration of justice into disrepute.
So you said paralegal also has a role, which means those police written and submitted case to the prosecution office. Paralegal can also check and identify any mistakes submitted by police. And how can you do in this kind of cases?
Yeah, so that's generally correct what you just outlined. Of course, it doesn't always have to be a mistake in judgment from the prosecution. They could just not agree that what you're asserting is a charter issue or a breach of the officer's duty to protect the charter interests of those who they're arresting meets the criteria for it to be withdrawn, for instance. And so it could also just be used to garner a better resolution pathway for your client. If the prosecution can see that there are certain areas that are weaker in their case, or that if brought to a motion hearing, could decimate the case depending on the trier of fact's decision on what was submitted. They may be more amenable to a resolution that's better for your client. But as far as how it's played out in the courts, you would essentially file a motion hearing before a judge. The prosecution would be served the same motion hearing so they can prepare, and then both sides would submit the reasons for and the reasons against why this is a charter issue or a charter breach. These things again stem from all the way from not getting access to counsel in a timely manner, all the way to what we call 11B issues, which is the right to have a trial without unreasonable delay. There was a landmark case here in Canada called RV Jordan, Jordan, where the courts put forward what we call a presumptive sealing, which is a period of time that is seen as taking too long, essentially, for lack of a better phrase, in prosecuting the individual. For Ontario Court of Justice matters, that's 18 months. And for Superior Court, which are more serious or where jury trials are held, Superior Court of Justice, 30 months. And this is not to say that you have to wait 18 months or 30 months to determine whether or not there's been unreasonable delay in the prosecution of your client. But these are an example of the type of motion hearings that are quite often filed in court. And a judge will hear the merits of both sides and determine, based on those arguments, what the proper remedy is. It could be something as simple as removing a piece of evidence that was obtained unlawfully or in contravention of our charter rights, or it could be something all the way up to the judge remedies the charter breach with a judicial stay, which is essentially nullifying the proceedings right there, right then and there. And so it's a forum where many options are available. Both sides get to argue, and the judge then determines, as I said, the validity of each argument. Yeah, well, so I mean, thankfully, the police and the prosecution are separate entities. One does not have weight against the other, so that works both ways, right? So an officer cannot, for instance, pressure a crown or a prosecutor to pursue charges that the crown or prosecutor wants to have withdrawn. They are removed from that process. They can have input. It's very common that crown attorneys seek what we call officer input or officer in charge input. That's the officer who's charged with handling the case file as far as providing disclosure to the crown, evidence, and so on and so forth. But they have no weight on the prosecution's decision, and vice versa. If it's deemed that an officer has breached some sort of charter right, the prosecution's office is not it does not punish them. It is not within their prerogative to do so. That would be an internal police issue. There are mechanisms in place where private citizens can lay complaints against police officers, and so that may couple with the motion hearing outside of the court. But as far as officer conduct, it is, and officers can be admonished on record by the judge, and they could be called out for their actions, but nothing from the judge or the prosecution comes from that. It would have to be an internal police disciplinary issue based on those mistakes. And if there are charter breaches or complaints, those are registered on the officer's, um, uh, you know, uh, 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 their record, or
So
their
you mean even prosecutor found any faults written by police, that prosecutor has nothing, no authority, any punishment or any action over police, but prosecutor may withdraw what police file the case. They
yeah.
can
So
dismiss the application. Only that prosecution office can do, but about punishment or any action over police, prosecution cannot do anything.
yeah, I mean, they may, if the police's or the police officer's conduct is so egregious, the prosecutor may call the police supervisor and say, look, this is what happened. You need to look into this, and that officer may the supervisor may then, of course, determine proper punishment for whatever it is that the officer had done. But as far as the separation of each individual aspect of the justice system, I think here in Ontario, it's quite perfectly expressed in that everybody is kind of in their own realm. And so if you, as an officer, make a mistake or lie, God forbid, or whatever it may be, It is an internal police disciplinary issue, much like if a prosecutor has been found with some sort of misconduct or something like that, that will be dealt with on a Minister of the Attorney General level. And if it meets the level of criminality, there may be charges laid, but it won't be as a result of recommendations from the prosecutor. It's very different than America, for instance, where as I said before, the district attorney has a lot of influence on what charges proceed, what charges are withdrawn. They kind of have that prerogative. Um, Here, I mean, the prosecution has a discretion to withdraw charges, but as far as the laying of charges and the processes that go into that, that's a police service prerogative, and it is disciplined and dealt with at that level.
I see.
Yeah, I mean, I'm not aware of any instances. If there are, it's more probably extremely rare where an actual judge has determined that police conduct has met the level of criminality and has suggested that criminal charges be laid. But again, to be quite clear, charges are laid by officers and by the police departments. That is their prerogative. No outside entity weighs in on that, and so officers have a lot of discretion in Ontario as far as whether or not to lay charges. And then as far as their misconduct, or alleged misconduct, I should say, that is dealt with at the police level. We also have a independent observer of police interactions that end in death or injury or sexual assault. It's called the ice the sorry, it's called the I believe it's wow, it's really the name's escaping me, but essentially it is a an outfit that would investigate the police's conduct that led to the death or injury or sexual that or alleged sexual assault, and they would look at it, and determine whether or not there has been police wrongdoing, and then they would make recommendations as to whether or not there should be formal charges laid against the police officer, if there was an actual any misconduct whatsoever, and if there is misconduct, what is an appropriate remedy for that misconduct, um, and so yeah, and so there are mechanisms sorry in place to rein in police behavior and alleged conduct, but each individual party in the court is separated without influence on the other, and I think that's the best way to do it because if everybody's afraid of what the higher seat may do to them, then we may not get the fair and unmitigated facts that are necessary to determine whether or not there's been an issue at all. So yeah.
I see. It said
Sorry, it's called the SIU. There it is. It came to me. Special Investigative Unit.
I mean, law enforcement are always sensitive, right? Police
Yes.
or military or any law enforcement are very sensitive, and the prosecution and the court, uh, uh, I mean, most of the time they are helpless or they are no power.
Well, and like I said, the remedy here is if an officer has done something to breach somebody's rights, the judge has the discretion to uh, you know, to make inadmissible all the evidence the officer gathered as a result of their investigation. And so that is a remedy in itself, right? And then that officer, of course, is now known to have done that, right? And whatever proceeds from that, um, you know, uh, what will. But again, supervising the officers, police chiefs, they're going to be made aware of these issues and what discipline they deem to be appropriate is necessary. We also have a very strong police union in Ontario, Canada, and so a lot of the times their unions push back on any type of discipline, and so it's an adversarial system across the board from those who are charged with the crimes, from all the way to those who charge people for crimes, and so it all plays out in its own form. I'm not going to make comments on whether or not it always works out in the good or the bad, but I will just say that I do truly appreciate our system, and I think it works. And I think globally it could be looked at as a really good model for how justice should be observed, and because that separation allows for more trust in the process. If you know that an officer can't pressure a crown, for instance, to pursue charges that are meritless, or that a crown can pressure an officer to get evidence that they're looking for, right, and trying to make a case be what it is not. And so that separation, I feel like, is truly important.
Of the case that submitted by police officer, prosecution and the court can do is they can dismiss the case, right? They they
Yes.
just they just uh, they just stop further because police is manipulated.
Yeah, I mean, look, so we have a regulator in Ontario called the Law Society of Ontario, the Law Society of Ontario, as well as the prosecution is ran by the Ministry of the Attorney General. And so, the punishment comes in many different forms. Much like the police, it could be that they lose the case, that their unreliability has been documented, and their false assertions or their neglect to properly observe charter issues or their place in the proceeding could have that type of effect, where essentially their case has been essentially dismissed by the courts, or they've been on the record. The judge on the record has admonished them for that carelessness in the caretaking of the case. Um, you know, and so it's they can be fired, for instance, if it's egregious, and I mean like very like to the point where there's some sort of criminality alleged. There may be charges that follow, and that's for the officers and the police department to determine. But and of course, somebody may make a complaint. So let's say the judge decides that there's been such an egregious overstep or straight up breaking of the law by not by a crown. They may email or reach out to the police department and say, look, this is what happened in my court. You may want to look into this. But for the most part, the punishment comes from the form of being publicly called out on record by the judge, by having their case dismissed. And it could also lead to them being fired. And as I said, in the most extreme cases, which I don't think is very often, they may be subject to formal criminal charges. The same thing goes with defense. There's a very famous case right now where allegedly a Canadian lawyer had aided another client in doing some illegal things, which I don't want to get into right now. But essentially, they've been publicly outed as doing such. The Law Society is looking into them and whether or not suspension or revocation of the license is appropriate. I think currently their license is on hold until the proceeding plays out. And they're facing criminal charges. They're currently in custody, I believe, if not just been recently released on bail. And so, nobody gets away in this country, anyways, with out and out, lying or misrepresentation of the record, whether it's something as serious as getting charged, which again is very rare, all the way up to your case being dismissed. There are remedies to deal with that type of nonsense. And so again, I'm very biased, but I really do believe that our Canadian justice system is something that the world should observe and view as a great guideline as far as how to structure the courts in their own country.
Isn't that prosecutor duty to do cross-checking all these police submitted file and cases and evidences, and they should whether to forward it or it should not be forwarded.
100%. And earlier in the interview, I talked about the case of Boucher, right? And Boucher in Ontario, Canada, or Canada, I should say, where it was quite firmly outlined what the prosecution's role is in the prosecution of offenses. And one of those things is that they have to follow the evidence where it takes them. They cannot have what's called tunnel vision, where they decide that this person's guilty and all other evidence be damned, right? And the same thing goes with preparation and their attention to the file. They cannot neglect the files. They have to give each file its proper observation and proceed upon its merits. My hats off to the prosecution team and the Ministry of Attorney General. They are very busy. They get hundreds of cases. They are overworked, and some may say underpaid. And so I don't want to, have it, be construed that my message here is that, prosecutors beware. But, these guys are subject to human nature and human issue. And when you get overworked and
Right.
you burn out, sometimes you miss things, right? And so not every single time a prosecutor neglects a file is it done out of purposeful act, right? Sometimes it's just a matter of just being burnt out because our system has not given them the proper tools and resources necessary to prosecute each individual file to the level in which each individual file deserves, right? Because each individual file is a person. That person is facing a life-changing situation. Whether or not they get convicted could change their life for several years. A criminal record in Ontario, Canada, can be very limiting. It could stop you from getting jobs. It can stop you from traveling. It could stop you from doing many things. And so it's very important that each file is taken care of and is proceeded upon on its merits. But if it's something that it's quite serious, they could be subject to other civil recourse or legal recourse, right? And I don't want to get into specifics because it's always going to be very circumstantial on a case by case basis. But I don't think saying at most is necessarily correct here. I just think one of the more common, I would say, remedies for such neglect would be a firing, right? To get you out of the office so that you no longer have that type of effect on future files. And I think that is an appropriate remedy. Not again, there needs to be a balance between human nature and the stresses that individuals go through and having such a high caseload, as well as individuals' rights to have their matter adjudicated properly. And so we
Right.
have to be careful and casting dispersions because it's quite easy for us to be like, this should have been done and that should have been done and this, that, and everybody has, as we say, I guess Monday night quarterbacking, right? Where you're at home on your couch and that he should have thrown the ball sooner. But it's so easy to do that with looking backwards, right? And so I always try to keep an open mind. I always teach my students that you should never close your mind to the other side. You should always understand the other side, see where they're coming from. That may greatly inform your arguments as well as inform your compassions and ensure that you're not treating the other side like the opposition, but just the other side of the coin, right? A lot of the times the prosecutor is not a bad person. They're just very tired and very overworked. And I know, and I have, and I feel for them on that in that regard.
Right. I guess it's also goes similar to the judges, right? Judges should not rely only prosecutor reported or the police reported document, right? Judge should be also cross-examined and verify evidences.
We have an independent judicial system, which means each judge gets to make decisions based on the merits of each case. Of course, we have stare decisis where we follow legal precedent, but at the same time, I rather live in a system where judges are, I wouldn't say free to do what they want, but have a lot more judicial discretion. I want to give benefit to those judges as they again are dealing with very serious matters. I will not pretend to know what they go through or what they have to decide. I do greatly appreciate the independent justice system that we have, where the judges get to be essentially independent minded and not governed in that way. I feel like that is the best way to mete out justice. I wrote an article here in Ontario for Canada called "We Defend the Rights of the Worst of Us to Ensure they're there for the Rest of Us," and judges are instrumental in this. Right, the law is supposed to be dispassionate. It's supposed to not rely on the emotional invocation of individuals, but on the merits of the facts of the case. And I think judges have a profound duty in that regard. And so it's not that I don't want to critique. It's more that I give the benefit of the doubt to judges, as I know these are individuals who take this role very seriously, that they greatly take care and precision in their decisions. I know many lawyers who become judges, and I watch them in their own, whether they were crown attorneys or whether they were defense attorneys, be zealous advocates of justice, and I know that has translated to their time as a judge. And I have a great respect for the judiciary system and people who sit upon that bench. And so it's not that I don't want to critique them. It's just that I don't believe I have the right to in my position now as a private citizen. I may have my own ponderings and my own things to think, but in my capacity as a paralegal, I always want to make sure that the public's view of the justice system is one that is strong and that is informed. And so thankfully in our system, the level of corrupt judges is, I would say, is very, very low to nil. And I think that's
You
a
see.
great thing. I think, and that's my opinion. Some may disagree with me and have specific anecdotal evidence as to who and what has been quote unquote corrupt. But I truly believe that when a judge is not tied by the mob, right, the rising tide of and drumbeat of the mob, that they can truly decide the case on the merits of the facts, right? A lot of people don't realize in court you don't argue the law, at least here in Canada, you argue the facts and how the law pertains to those facts.
You see. So uh, it is appreciated. You said a lot of Canadian judges are very low corruption. It's strongly appreciated in Canada.
There's I believe judges have a there's a way for the people who complained against judges if they believe that they've been unfair or they didn't, do their job effectually. Uh, there are, the Canadian Judicial Council, for instance, would handle those complaints. But again, I just want to be fair here and careful in the way in which I describe this, because my job as a paralegal is to uphold the perception of the administration of justice. I can tell you from my own experience, providing legal services for almost for 10 years now, that I have only come across some of the very best people who become judges and take their role very seriously and do not use that role to mete out the justice that they deem to be fit based on bias or based on corruption. I truly believe our system is world renowned, and that our judges are the one of the largest proponents, are sorry, the largest components to that, the way the world sees our justice system. And I think that's a great thing. I don't think that's necessarily taking away from the discussion if I'm not willing to condemn judges personally or individually. I think on the whole, we are well served by our judges, and we live by their decisions every day in what we call common law. And so I am, again, very appreciative of all the hard work that judges put
You
forward
see,
on behalf of our country.
I mean, Canada will be probably very good judges.
Yeah. I mean, look, me personally, no, I've never in my personal capacity been aware of this, but it is something that the Canadian Judicial Council can do. They can suspend a judge, they can remove a judge from their seat, they can sanction a judge for inappropriate conduct or negligence. But I'm sure there's a list of those judges somewhere on Google that somebody could find. I am thankful to say though that in my capacity as a paralegal for 10 years, I've only had the best, and I'm in court every single day, dealing with multiple judges, and I've only ever seen judges act admirably.
You are very lucky. You have a lot of good judges. Good
I agree.
judges. You are working with a lot of good judges. You never saw any corrupt judges or any judges were fired or removed from duty. So it means very you are very lucky. And I mean, if the judge is the highest power, in judicial system, and the judge should be respectable. The judge should be the most respectable. If the judge is not respectable, and if the judge is out of common sense, out of constitution, out of justice, if unfair behavior, I mean, the whole country is finished because the justice on the top, if the top is something wrong, if unrespectable judges and the highest, the most important in judicial system.
I
I mean,
agree. I wholeheartedly agree with that sentiment there. I mean, and I've taught this to my students over the last 4 years I've been teaching. The When the judicial system goes, when it falters, when it falls, when it fails, society usually tumbles after, quite soon afterwards. It is the last true protective barrier from governments that overreach, from societies
right.
that need to work together, especially multicultural societies where we're dealing with many different belief structures, many different cultural upbringings. The law and the application of the law becomes absolutely paramount in ensuring that a
Right.
society can function collectively. And when a judge doesn't do their job, when the justice system doesn't work, it is an absolute terrifying premise because then individuals can be scooped up off the street without recourse. Cases can be decided not on merit but on emotion or on things outside of proper legal observations. It is essential to any functioning society that the judicial system works and that it works independently from political and governmental influence, because a truly independent justice system not only protects citizens from each other, but citizens from the state. And without that protection, we become autocracies.
Right.
Um, it becomes dictatorships. It becomes
Definitely.
emperors, and we cannot go back there. People don't realize how rare this slice of time is in for us in humanity. This is not where we are right now is not something that's been observed throughout the history of human of the human endeavor. It has always been some sort of autocracy or monarchy or dictatorship, and now we live in a time where individual rights are paramount, and we have to protect that. And the way we protect that is ensuring that our judicial system is working properly and that there is appropriate remedies in place to ensure that it functions properly. We have the Human Rights Tribunal, which is a based on a human rights code in Canada and Ontario. Again, that's separate and aside because the charter protects us from the state and the state's overreach, whereas the Human Rights Code protects private interactions, right? So let's say somebody discriminates against somebody else based on religion or culture and doesn't allow them to purchase or utilize their services that are regularly purchased or utilized by the public. That would be dealt with in the human rights tribunals, and that's a well-represented area of law. There's a lot of ongoing cases there. Whether they have merit or not, that's determinative by the adjudicators that sit in that forum. But we definitely have protections for private interactions. Canada is a place where we greatly respect uh, all cultures, all beliefs, sometimes to our detriment. Some of the world sees us as a little bit too left thinking in that regard. Some people view our country as a little bit too left leaning as far as our observations of individual rights. But I would always argue that we should always err on the side of caution in that regard, and that human expression is something that should be safeguarded and protected. Because again, if we start deciding what other people should be doing with their life or their decisions, then we're not truly a free society. We are a society that's based on the freedom of and the thought of what individuals think should be appropriate. Of course, that is within bounds and reason. Somebody shouldn't have the right to just shoot their gun indiscriminately down the street. At the same time, though, there should be protections in the law and the Human Rights Code enshrines these for the expression of your culture, the expression of your religion, and just generally being who you want to be in this world. And I tell people all the time, we're on a flying mud rock, whipping through space at breakneck speeds, whipping around a nuclear reactor, and everybody pretends like they know what's going on. In reality, we're all just doing our best to figure it out while we whip through time and space and the vastness of the universe. I know that's quite philosophical, but in my mind, I think it's also grounding and humbling that we all, it's we all think this is the biggest playground in that we have, but meanwhile, we're a tiny speck in the vastness that is our galaxy, and even then, that galaxy is a speck in the vastness of the universe.
You see. So I hope human rights organization, you said Human Rights Tribunal in Canada also side by side with the justice system, right? If any human rights violation,
So
they should be useful for the people. So I don't know, maybe you did not see much human rights organization activity beside justice's judicial system.
no, so I don't practice in human rights code. I do criminal law, but I have done a lot of work with individuals that I call friends and colleagues in the protection of human rights, whether it's for anti-Black racism, which tends to be an issue here in Canada as well as America. And and the functions that come with that. I've sat with government officials discussing how to best allocate funding for anti-Black racism, and so I've worked hand in glove with a lot of individuals seeking to ensure that individual human rights are respected and observed. I have not, on the other end, though, I have not personally fought in human rights court or the tribunal, sorry, but I have colleagues who do, and we've had very, very, you know, um, informative discussions. And my mind is always about individual rights within reason.
I mean, in Canada, Human Rights Commission, you said Human Rights Tribunal, maybe they don't have much power, right? I mean,
No,
it's
well, they have certain tools or arrows in the quiver, right? So they could issue a monetary penalty, right? And so much like civil court, somebody could be awarded an amount of money that the Human Rights Tribunal board member deems to be appropriate in remedying the damages that the individual has received as a result of the human rights violation. There could also be other punishments, by the courts, but it's not the same as the criminal justice system, which is the state punishing you for breaking statutory law or common law.
the Human Rights Tribunal supposed to be independent, right?
That's correct. It's its own area of law with its own tribunal that hears um, matters. There's no criminal penalty that's associated with it, but there's monetary compensation. There could be people that file false, for instance, human rights issues could see reprisals as a result, including costs awarded for the legal representation that the other side had to obtain. But it is essentially in its own area.
Right. So independent.
It's
It's
independent, yeah.
independent institute. I mean, because people will also know that sooner or later, whatever judge, justice or not justice. So if the judge want to be respectable judge or respectable court, I don't know, you saw any cases the court
Well, I
withdraw
mean, yeah.
withdraw the that they already made uh, indicted or decided case.
So as far as like my general understandings, I again, as paralegals, we can't argue at the Supreme Court level, right? Our level is right at the provincial court level. Supreme Court, of course, creates law of the land through common law. But if they deem something to be incorrect or something comes up that changes the entirety of what they decided, they do have the right to revoke a previous decision.
I see.
And so they can go back and correct that wrong. Whether or not it's something that happens often, I can't give you a direct answer on that. But there is a remedy in place that allows for the Supreme
I
Court to
see.
correct the wrong in which they've decided.
They can revoke it, right? The
Yeah,
court can revoke it again. So I mean,
yeah,
that is fair enough because I mean, judge can be also mistake or somehow they did decision,
yeah.
indicted or something. So they can revoke it again. Then I mean that will be fair enough. You can say like that.
Everybody has a right in Canada to hear their trial or their case in their chosen tongue. It is a fundamental requirement for the fairness of justice and the procedural fairness that is justice in
Right.
Canada. And so we have a long list of well vetted and well prepared government issued translators because a lot of people don't realize translation one-to-one translations don't always necessarily contextually match, right? Some cultures are more descriptive in their language, whereas English has been essentially known to be quite blunt. It's a very blunt language. Whereas, as I said, other cultures are very descriptive, and so it's not just only about the one-to-one translation, but also the context of what's being stated, so the individual understands it in their tongue. But it's a fundamental right of individuals to be able to understand what's going on in their mother tongue. It could also be a means as to why a trial cannot go on and why a trial could be stayed or discontinued if we can't find somebody that speaks their language, right? And as you probably are aware, it's not just only about multiple language, but also regional dialects, right? So somebody could be from India. It doesn't mean they speak Punjabi, for instance. They could speak a very regional dialect that is not well represented in the court's list of translators, and that could be an issue for their ability to receive fair justice.
I see. The main idea is what is written and what they are talking about, what is the judgment. The main thing is they should understand either their own language or any understandable language, right? So
Agreed.
if they are not understandable language, which means it's a communication problem, right? Because until unless that person is understand what the court is saying, what the court is written, it doesn't understand.
Yeah. So, I mean, look, here, if we can't find the appropriate translator for the proceeding, it's more often than not the matter will be adjourned for which means put to another date for a translator to be located. Now there's levels to this because if the continuing delay occurs, it's a institutional prerogative to obtain proper appropriate translators. And so if they're not able to do so, and it's been a long period of time or a few adjournments, we may be, as I discussed earlier, in 11B territory, where the court may dismiss the case based on the fact that it's taken an unreasonably long time to prosecute the individual. But it's absolutely necessary to proceed with a translator when somebody does not speak the English or doesn't speak it very well, right? Because somebody could speak broken English and understand, very, surface level communications, but for something as serious as a trial, they need to be understanding all the nuances of what's being discussed. And so the court has a right under fairness, under the procedures that we identify as, fairness and justice, that they are able
Right.
to understand the proceedings in full. And if the judge were to proceed without that translator, it would definitely be an appealable issue where you would raise the fact that the individual had not been able to understand the proceedings, therefore it wasn't a fair hearing. It wasn't a true adversarial hearing.
So it means it's unfair, it is injustice.
Correct. It is 100% unjust to proceed in a trial without the individual who's facing uh, prosecution being able to understand the proceedings. So in the charter, section 14 of the charter guarantees us the right to have the proceedings done so in a language that the individual facing charges understands. If the court acts in contravention of that charter right, then again you would assert your client's right, your fundamental human right under the charter to have the trial heard in the language that they understand. Right? It's the court's prerogative. We in Canada truly believe in fair justice, and that the only way for fair justice to be had in this situation would be an individual to fully understand and appreciate what's happening to them. It would be an
Right.
absolute, to me, it'd be an absolute affront to the justice system on a global whole, where individuals don't understand the reasonings for their detention or their potential jail time or charges. And so that it's unfortunate to hear that some countries don't believe in that and hold it to the same high regard, but it's enshrined in our charter, section 14, that individuals have the right to have an interpreter for assistance in a language that they speak.
I see. So, I mean, that's fair enough. Canada is doing very good and very good regulation and very justice system in case of this communication with they
Mhm.
make sure all individual understand, able to communicate with the court, with the prosecution. So, I mean, it's fair enough in Canada, and Canada justice system is doing very good compared to many other countries,
Yeah,
they get
it's not
much.
like it's not like we're without fault. I don't want to give the false premise or presentation that Canada is a perfect place without mistakes. There's always going to be
Cost.
mistakes, but I believe truly that our system is skewed towards trying to ensure that the most fair and equitable administration of justice is done, and I take pride in that, and I'm very proud of the work that my country and my judicial system does and has done for since its inception. And I can only hope that going forward that we continue on that pathway. Things the mob is getting louder because there's a fundamental misunderstanding of some of the processes and procedures of the justice system. The presumption of innocence, for instance, seems to be falling by the wayside. A lot of people now just want people convicted based on their gut feeling, want people detained in jail before their trial, before an actual trial has been held to determine their level of guilt or if they're guilty at all. And so these are problems that we're facing currently
Right,
in the
right,
ever escalating gathering of the mob. But I feel like there's enough safeguards in place in our system that will protect us from that. Of course, politicians, when they play into these things to get power, when they misrepresent understandings knowingly in order to get individuals fever up so they can get them roused up. That is also a problem, and I think we're seeing that happen across the globe. It's not just a Canadian problem. The gathering of the mob is something that's happening in most Western civilizations currently and other places around the world.
when you talk about politics, I remember, I mean, some judges or lawyer or prosecutor, uh, I'm not sure it's relevant or not. They said, uh, we will we will do the case based on the people, based on the people reaction. It is loosely it is mentioning. I mean, they are not politicians. They are they are legal, judicial, uh, judicial worker. They are in judicial system.
Yeah, and look, there is no doubting that, as I just stated, the gathering of the mob, the ever encroaching drumbeat of the mob, is making its way towards the legal world. Things like Canada, for instance, where we have a bail system where the presumption of innocence is paramount. Individuals should be released on bail unless there are certain grounds for the detention that are proven. More and more people are not satisfied with that based on the perception of the rise in crime in Canada. I mean, I would also argue statistically, crime is lowered in Canada over the last decade. But perceptionally, that's what the mob relies upon, the perception, not the reality. And that's why it's important for us to continue to separate the law from the will of the mob. Now, that doesn't mean, though, that there are certain legal issues that shouldn't be contemplated with respect to how the society may feel about those things. But
Right.
that doesn't mean, though, that we should be bound by the mob. But there was a great example of a woman a few years ago in Toronto, Ontario, Canada, that unfortunately stabbed and murdered another woman. Now, the media was transfixed on the fact that she was classically, quote unquote, beautiful. And therefore, a lot of the contemplation around her crime was not about why she did the crime or how she did the crime, but why would somebody so beautiful do the crime? And so, human perception needs to be far removed from the law because we tend to think in such ridiculous terms. Oh, this person's beautiful, they can't be guilty. This person's ugly, they must be guilty. And that's a problem that is a human nature problem. We love shiny things. We love to look at things that we want to emulate towards. And then we also want to do away with things that we find to be not within our standard of beautiful or nice. And so that's why I love the law. It's just passionate. It is based on the facts and not on the feelings of those facts.
Right.
And thankfully, and there's a place for those feelings, though, right? Sentencing, for instance, if the person's found guilty after all the facts are laid out, then we start talking about society's view of the crimes. We start talking about the individual's personal issues. That's when the emotion aspect comes in. And so there's a place for it, right? There's a proper position for it in that system.
Judge and prosecutor are not politicians, you know.
That's right.
They should not act as politicians.
I agree.
So thank you very much, Justin, for today. I mean, we did a lot of broad discussion, and I
Yeah.
think it's very helpful for legal counseling to the many people.
Thank you for having me.